Good morning and good afternoon. Good morning in Texas and good afternoon in Malta. My name is Aurélien Orange and with Miss Urbanova from the Corask Foundation we'll have a match of the round of 16. This is actually the 7th out of 8 match of the round of 16 that we have today between the University of Malta and the University of Texas at Austin. I give the floor to my colleague.
Thank you very much. And indeed, good day, good morning, and good early afternoon for the students today. And also big thank you to the 3 judges that will be reviewing or perhaps already are reviewing this debate. The topic for the students today to discuss or debate is whether or not governments must prohibit public sector AI decisions without meaningful human review. As always, before we start, I would like to give the floor to the students for introductions, starting with Ms. Feinstein of University of Texas at Austin.
Hi, my name is Lindsay Jade Feinstein, and I'm so excited and grateful to be representing UT Austin today.
Thank you. Welcome, Ms. Aquilina of University of Malta.
Hello, everybody. Good morning to the colleagues in Texas. Thank you for being here for this debate. We're really looking forward to it, and I'm sure it's going to be fruitful.
Thank you. Welcome, Ms. Raj Patak of University of Texas at Austin.
Hi, I'm Ruta from UT Austin, and I'm really excited for this opportunity.
Thank you. Welcome, Mr. Gatt of University of Malta.
Hi, Michael from University of Malta as well. Looking forward to another fruitful debate, hopefully, and best of luck to you esteemed colleagues from Austin.
Thank you. Welcome, Mr. O'Rourke of University of Texas at Austin.
Hi, I'm Gordy O'Rourke, and I'm really excited to be representing UT and for this debate.
Thank you. Welcome. Also, I would like to highlight the support for the teams. So for University of Texas at Austin, we have Dr. Benke and Mr. Dill that support the teams from their position as mentors and coaches. And for University of Malta, it's Dr. Grima, Professor Gretsch, Dr. Komedini Kasia, and Dean Mifsud. As Dean Mifsud is with us, if there are words of encouragement you would like to share for the students before we start.
Hi. Okay, so good afternoon or good morning to our colleagues in Texas. We're very excited. We've been really enjoying every single round. It's our first time participating, and hopefully, always if I find such good students as I found this year, we'll be back in future years as well. Best of luck to all.
Thank you very much. And in a short moment, your teams should be able to see the screen for the allocation of positions. If I can just get a confirmation when you do.
Yes.
Thank you. So 4 possibilities, 2 for each team. And in today's debate, it will be the University of Malta that will be representing the in favor position, thus starting the debate with their opening statements and arguing for that governments must prohibit public sector AI decisions without meaningful human review. You now have 5 minutes to finalize your preparations. Feel free to close your cameras. Thank you very much. This marks the end of your preparation time. We'll start by hearing the opening statements. Just a short reminder, yellow card indicates 30 seconds left, red card indicates speaking time is over, but you will still have the time to comfortably conclude your last sentence. All right, without further ado, University of Malta, you have 4 minutes.
Thank you. Am I audible and visible?
You are.
I will start in 3, 2, 1. Honourable judges, esteemed colleagues, good afternoon. The motion asks whether governments must prohibit public sector AI decisions without meaningful human review. We submit that they must on 3 grounds. The rule of law demands it, the empirical record proves it, and the law increasingly requires it. On the rule of law, state decisions reach into the most fundamental aspects of human life. The rule of law has for centuries demanded that such decisions be made by a human being who can understand the facts, exercise judgment, give reasons, and be held accountable. In fact, Article 22 of the GDPR codifies this. Individuals have the right not to face solely automated decisions producing legal effects. It also requires safeguards, including the right to human intervention. The CJEU in the SCUFA case confirmed that this right turns on the practical effect of the automated output, not on the formal label attached to it. Article 14 of the EU AI Act mandates human oversight for high-risk systems with the genuine power to override their outputs. In the case of State versus Loomis, the Wisconsin Supreme Court permitted Compass only on the express condition that algorithmic risk scores could not be determinative. As articulated in the case of Lavender versus Minister of Housing, a decision maker must not surrender judgment to another body, let alone to a non-human system. Thus, where state power affects individual rights, an accountable human must remain in the decisional chain. Onto the empirical record, in the Netherlands, the Toshlan-Gaffer algorithm flagged 26,000 families as fraudsters using nationality and foreign-sounding names as fraud indicators. The Dutch government has since formally admitted that institutional racism was the root cause. Amnesty called it a xenophobic machine. Thousands were driven into poverty, over 1,100 children were taken into state care. In Australia, the Robodebt scheme issued 526,000 unlawful debt notices using an income averaging methodology that the Royal Commission found unlawful from inception. And then in the Netherlands, again, the Siri system was struck down by the Hague District Court as a violation of Article 8 of the European Convention of Human Rights. These are not isolated incidents, but display what unreviewed public sector AI does at scale, which is that it multiplies error across vulnerable populations and renders that error almost impossible to contest. And the third ground is proportionality. The motion does not ban AI in government. AI can flag cases, can detect patterns, it can assist officials. What the motion prohibits is AI as the final decision maker where serious rights are affected. The Italian Consiglio di Stato drew the same line in its judgments. Algorithms may execute standardized procedures, but they may not exercise discretionary judgment. New York's Loading Act goes further than this motion, prohibiting automated decision-making in public assistance programs altogether. The American Federal Policy M2521 mandates human oversight for all high-impact federal AI. Behind every algorithmic decision is a person's life. Behind every wrongful one, a life upended. The motion asks governments to weigh costs before they surrender the judgment owed to those they govern. We therefore urge you to support this motion. Thank you.
Thank you. Now for the opening statement in the against position, University of Texas at Austin.
Can you hear me?
Yes.
Okay. Thank you to our esteemed judges and opponents from Malta for joining us in today's debate. We are proud to negate the topic that governments must prohibit public sector AI decisions without meaningful human review. We will now introduce our contentions. First is mandating human review overloads already slow public sectors. Second is human review will prioritize profit over public interest. And third, the globally accepted legal frameworks do not include specific regulations mandating human review. First, mandating human review will overload already slow public sector systems. In the status quo, international governments in the public sector operate on a large scale without delays to immigration systems, healthcare, and welfare systems. By affirming this resolution, states put themselves at a disadvantage of needing to add an additional step of human review to an already slow and inefficient system, requiring labor needs beyond the scope of existing systems. In a legal review by the International Journal of Criminal Justice Science, they detail that the International Covenant on Civil and Political Rights mandates a timely review of all violations. This review details that following the Islamic State's 2019 violation of human rights in Iraq, they delayed investigation due to a lack of human labor, left vulnerable people at the mercy of the militia, meaning that the necessity of human review was more harmful than a fast, automated decision. In a multitude of already overwhelmed fields, the requirement of a human review will cause a labor shortage that will only continue to harm disenfranchised and vulnerable populations. Second, human review prioritizes profit over public interest. Humans are subject to profit motives, bias, and corruption in ways that objective data through automation can overcome. For example, profit motives have often prevented public sector action on combating climate change. Climate research at the World Resources Institute have found that AI increases the ability to gain accurate and powerful insights on ensuring organizations are meeting their climate obligations, using AI to prioritize public interest over profit. Additionally, emerging AI-powered climate monitoring systems can help to track the impacts of climate change and mitigate climate-related disasters before they start. Mandating human review allows for potential for climate deniers or politicians backed by lobbying interests to skew these insights and resulting policies. Third is the globally accepted legal frameworks do not specifically mandate human review of automated decisions. Attempting to implement this at an international level would be unenforceable at best and infringe on states' sovereign decision-making at worst. The International Covenant on Civil and Political Rights requires, quote, fairness and non-arbitrariness. It does not mandate the human involvement in every decision. While AI may be imperfect, there is no denying that unlike humans, its decisions are objective, which is certainly just as, if not more fair than humans. Intervening in a sovereign country's decision-making process to monitor their AI use is unjust and unsupported in international law. Case law also supports this premise. In the United States versus Loomis, a judge was permitted to utilize a risk assessment algorithm that can be beneficial for defendants. Several sources, including the state court report, have found that judges are subject to implicit racial biases, confirmation bias, anchoring bias, hindsight bias, and political bias. This can result in ridiculous sentencing disparities, such as the 2016 LSU study found that judges gave sentences resulting in over 1,000 extra days on probation or custody if their football team of choice had just lost a game. And a 2011 study found that judges gave more favorable sentencing if they were less hungry, such as right after lunchtime or late in the afternoon. AI doesn't root for football teams or get hungry, and in some instances, that makes it a better judge. For these reasons, we urge you to negate the resolution. Thank you.
Thank you very much. We'll now proceed to hear the rebuttals. University of Malta, first rebuttal in favor. 2 minutes.
Thank you. Am I audible and visible?
You are.
Yes. In 3, 2, 1. This debate is not about whether AI can be useful. It is about whether governments should be allowed to make decisions about people's lives without meaningful human judgment. In the Global South, we already know the answer because we have seen what happens to them. Take KSP versus Union of India. India's biometric Andhar system was upheld, yes, but only with strict safeguards. The court made it clear technology cannot override fundamental rights like privacy and dignity. The system had to include human accountability and proportionality. Now look at Kenya. In the Huduma Namba case, the government attempted to roll out a national digital ID system. The court stopped full implementation until the protection safeguards were in place. Why? Because automated systems without oversight create exclusion, especially for vulnerable populations who cannot challenge errors. And in South Africa, in Black Sash Trust versus Minister of Social Development, the court intervened to protect millions of welfare recipients when automated grant systems risked collapsing. The judgment emphasized that states have constitutional duty to ensure fair and accountable delivery of benefits, Across these cases, the message is consistent. Technology is allowed, but only when humans remain meaningfully in control. Because in the global south, when systems fail, people do not just lose convenience, they lose access to welfare, legal identity, basic survival, which means that this motion is not radical, it is a minimum safeguard. Without meaningful human review, errors become systematic and injustice becomes automated. That is why we are in the affirmative of this case, because alone, there have been many cases to back the facts of this case as well. Take as well the global case of the Dutch welfare scandal. Similar risks are developing in different contexts as well. So it's vital to keep in mind that without rights, they only exist on paper in this case. This motion protects not just individuals, but the integrity of governance itself. Thank you.
Thank you very much. And we'll now proceed to hear the first rebuttal in the against position, University of Texas at Austin.
Thank you to our esteemed opponents for their perspective. We contend that you ought to prefer legal precedent from cases from the International Covenant on Civil and Political Rights, which do not mandate human review, but instead rather a fair process and timely review. The affirmative mentions the Global South, but this belies the fact that the only legal precedent for their argument is overwhelmingly skewed towards European nations, as the rule of law precedent they have cited is the GDPR and the European Union, which proves that their legal standards are not in fact globally recognized, whereas ours are. GDPR laws are also majority created from private sector involvement, making these definitions inaccurate for capturing the full scale of public sector AI involvement. Public sector decisions operate fundamentally differently than the private sector, as they don't prioritize profit and instead address the need to address the entire population of the state. As per their examples of AI bias, institutional racism is also compounded by biased individuals. Their examples are not reasons to favor the affirmative, because the topic states that any AI decision without meaningful human oversight must be prohibited. Therefore, the worst cases of unfettered AI still could be mitigated in a world without this international obligation, but the affirmative would preclude any public sector use of AI without human involvement, which means that if you can think of a single instance where an algorithm would be less biased or less corrupt than a politician, you ought to negate this topic. AI will not opt to add 1,000 days to someone's sentence because their football team has just lost, but allowing a judge to intervene might override it and create these biased decisions. Therefore, the risk of lack of resources and the risk of human bias outweighs the risk of AI being imperfect in some cases in the instance of this topic, given that the international precedent is not legally supported in the rule of law, and that intervening in this case would undermine individual states' decision-making and sovereignty. Thank you.
Thank you. For the second rebuttal in favor, University of Malta.
Am I audible and visible?
You are.
I will begin in 3, 2, 1. To rebut the point that our esteemed opponents mentioned of our arguments being a bit too Eurocentric, just like to remind you that we've mentioned the New York Loading Act, American Federal Policy M2521, and other cases which are beyond Europe as well. But to continue on the point that the opposition made about algorithms are less biased than humans, this is the most tested empirical claim in the AI debate, and the evidence is unambiguous. AI doesn't eliminate bias, it scales bias. In fact, ProPublica's 2016 investigation of the Compass recidivism algorithm basically found it nearly twice as likely to falsely flag Black defendants as high risk, even when controlling for prior offending. And then the Dutch case that I mentioned prior, the algorithm operationalized racial profiling at scale. So nationality and foreign sounding names, in fact, functioned as fraud indicators from 2013 onwards. The Dutch government formally admitted in May of 2022 that there was institutional racism, and that was the root cause. Siri was deployed also exclusively in low-income minority neighborhoods, and the Court of Justice in the Scoofa case confirmed that the legal test is functional impact, not formal intent. So an algorithm which is trained on biased data is not the cure for bias, it's just bias with a quieter voice. And to focus on the element of sovereignty that our colleagues mentioned, basically human rights instruments, they all use mandatory language precisely of this kind. The ECHR doesn't guarantee that everyone shall have that they shall have the right to a fair trial, not that they may or they should or where it's convenient to have this. So basically on the sovereignty point as well, the sovereignty argument proves too much. So states must respect the ECHR, they must apply the GDPR, they must honor the Council of Europe Framework Convention. So if must is impermissible, then the opposition's own preferred framework collapses. Thank you.
Thank you. For the second rebuttal in the against position, University of Texas at Austin.
Thank you to our opponents and judges. We contend that the risk of lack of resources outweighs the risk of AI being imperfect in the isolated incidents and examples that the negative has given. The risk of excluding automation cannot be taken. Due to expanding population levels and limited resources, delayed investigations into issues or delayed distribution of resources cause human rights violations and leave global issues unaddressed. Mandating human review in every decision will add delays to immigration systems, healthcare, and welfare systems, and would disproportionately affect already under-resourced countries, which means that even if imperfect, you should utilize automation in decision making, especially for countries that may not have the resources to hire a human to look into every single instance of suspected fraud in welfare systems, for example. The Compass algorithm example shows that AI bias can in fact be quantified and corrected for, but the same is not true of humans. The affirmative has no way to account for the bias in, say, an individual judge. Additionally, they have not answered our examples about the profit motive skewing politicians away from solving crises such as climate change, whereas things like AI algorithmic monitoring create fair and just data that leaves no choice but to take action. Additionally, the Interpol has utilized AI-powered facial recognition technology itself and reports that biometrics have been utilized to identify terrorists, criminals, fugitives, and even counter human trafficking by identifying missing persons. Not only are these examples of positive AI use cases, but it also proves that it would be unjust to hold individual countries to a standard that the international community itself does not follow. And not only that, but it would likely exacerbate inequities within the global south and is also unsupported by the International Covenant on Civil and Political Rights, which is the best global framework for this debate, as the affirmative is citing fragmented laws such as the EU and GDPR that are not universally applicable. Thank you.
Thank you. This marks the end of rebuttals. Proceeding to hear the concluding statements, starting with the in favor position, University of Malta.
Thank you. Am I audible and visible?
You are.
Yes, perfect. So I will start in 3, 2, 1. After all this argumentation, 3 propositions remain on the record at the close of this debate, and they have not been displaced yet. The first is that the right to human review of consequential public sector decisions is already established. All the legislation we have cited converge on the same principle. State decisions affecting individual rights cannot be left to machines alone. The motion does not invent this right, it universalizes it. The second is that the empirical case for human review is not speculative. 26,000 Dutch families, 526,000 unlawful Australian death notices, over 1,000 children separated from their parents. A government brought down. These outcomes happened because human review was either absent or, where present, reduced to symbolic clicking. The motion responds to a documented harm within a documented remedy. The third is that a safeguard to the motion requires is proportionate. AI can continue to flag, prioritize, and analyze. What it cannot do, where serious rights are at stake, is decide alone. The opposition has not shown what categorical right the motion violates, only what convenience it constrains. They speak of efficiency, but efficiency without accountability is not governance, it is automation. And automation cannot answer for the lives it shapes. Convenience is not a right. Meaningful human review is not bureaucratic friction, it is a reducible minimum of accountable governance in the algorithmic era. To reject this motion is to accept that decisions taken by no one and explained by no one can determine the lives of the most vulnerable. We will not permit convenience to supersede fundamental human rights. That is not a future we should permit. The problem is, AI systems cannot explain itself in legal terms, it cannot justify reasons, it cannot be cross-examined. So if a decision is made solely by AI, who is accountable? The answer becomes unclear, and that is precisely what the rule of law cannot tolerate. Someone must understand the decision, someone must be able to explain it, and someone must be responsible for it. Thank you.
Thank you. Now for the concluding statements of the against position, University of Texas at Austin.
Am I audible and visible?
You are.
Thank you, judges, and to our opponents. To summarize our opponent's argument, the question is whether a blanket prohibition on AI decisions without human review will actually improve the outcomes. Now, the first speaker points out the scaling issue. While they suggest that human review only needs to be the final decision maker, as we've stated, human review has historically been harmful to marginalized populations. Smaller governments have been weakened by these same systemic factors, like our examples of the Iraqi government in 2019, and will only continue to worsen systemic harms. Especially when we look to examples like the Interpol's use of AI, we can see that some countries have chosen to require humans in the loop. It would be hypocritical of the international community to impose this standard. Further, the affirmation must address the international trends towards private profiteering. As the majority of our examples our opponents have referenced have come from private corporations, since they're developing a majority of the technology used with these biases. It's very convenient to be able to rely on data and examples of automation created from the private sector, but it isn't a true systemic solution. Human systems themselves are not neutral and can be subject to political pressure, lobbying, and resource constraints. The second speaker brings up a multitude of examples of courts preventing technological examples out of fear of bias, but our arguments of human bias have time and time again proven themselves to be the status quo. AI provides us the opportunity to envision a world free of human bias and discrimination. When we're accountable to no one and explained by no one is much more applicable to biased judges who add thousands of days to people's sentences on the basis of their preferred football team, rather than prioritizing an unbiased algorithm. Our opponents argue for a world that has significantly more backlog, slower systems, and worst of all, has a more biased world. However, our team argues for a system with greater access to these types of rulings and less bias overall. Their argumentation regulates a perfect world where judges are essentially free of bias, but our arguments support a realistic world that will accommodate for all of our circumstances. If we create automated systems that can make more effective decisions, we can prioritize this that can prevent bias. Thank you, and we urge your vote in the negation.
Thank you very much. This marks the end of your 8th finals debate. Congratulations. You can all now relax. You're no longer evaluated after this part. Well, most importantly, I want to congratulate both teams on concluding your debate in the round of 16. Well done. It's been a pleasure to see your debates from the first until today's. Of course, the judges have the time to review and submit the evaluation sheets. Once we get them, the organizing team, when they confirm it, will share them with you and, of course, announce the results. But as always, as this is our practice, I would like to invite you already to share your feedback for the debate today on how you have approached the research, perhaps, and if you heard familiar arguments from the opposing side from your own preparations. Starting with Mr. O'Rourke of University of Texas at Austin.
I enjoyed this topic. I thought it was interesting, and initially, when we got the motion, I was my reaction was interesting because I was initially like, seems like it's a very affirmative leaning topic. So I think that was something that we initially kind of had to grapple with. We had also encountered the GDPR definitions, and I think we used the same case, United States versus Loomis, in both of our introductory speeches that ended up not impacting this debate, but I think that that's kind of interesting. But yeah, I thought it was an interesting topic, and I liked researching it.
Oh, thank you very much. And now for Ms. Aquilina of University of Malta.
Firstly, I'd like to thank the colleagues from Texas for waking up so early and for being able to debate with us at that hour of the day as well. And it was very interesting, as you mentioned. The research, of course, on both ends I love this opportunity because it requires us to see a motion from both sides, which is really good to maintain a balanced perspective on everything in life. So that's a really good skill that we've been able to develop. And even just to be able to see the amount of legislation and cases that are available on this particular topic, both in Europe and even beyond, is really interesting, considering it's such a timely topic. So looking forward to learn more about it and the developments that are yet to come, because it's a forward-moving area of law as well. So this is just the stepping stone and the starting point of more that we have to learn in this regard as well.
Thank you very much. And now to Ms. Feinstein.
Yes, thank you to our opponents for having this debate and to you all for organizing it. I think that this topic is definitely very timely, considering just all of the advancement and increased application of artificial intelligence. So I thought that it was really interesting to be able to look into how maybe existing international legal frameworks might apply to this more modern technology, in addition to some of the specific emerging cases. And then within that, it was kind of interesting to say we might agree on some international legal principles, such as fairness or due process, but then arguing over, okay, which application of this technology is more fair versus less fair, I think was very interesting for sure.
Thank you. Now to Mr. Gott.
I'm going to basically reiterate the points made by everyone. Firstly, thank you for the organization of such an interesting topic, because I think it encapsulates the modern era very well. And it's something very different to the topics we've had previous to the debate as well. I think that the debate was very fruitful as well. I very much appreciated the points made by the opponents here. We encountered very similar topics when researching ourselves, so kudos to you, of course. It was a healthy debate as well, and we thank you for participating in it as well.
Thank you. Ms. Rashpatak.
Yeah, to kind of just add on to what everyone else was saying, I really enjoyed the opportunity to debate a topic that was so nuanced. I think to be able to engage with this topic, we had to go into so much specific detail about the nuances of international law and learn all sorts of forms of history about how these types of systems have been used. And that was a really wonderful opportunity to be able to get that perspective.
Thank you very much. And as we have one of the mentors of the teams present on the call, I would like to see if Dean Mifsud, if there's anything you would like to share with the teams for the encouragement on the debate.
Yeah, for my part, what I'd like to say is that on a personal basis, as soon as I saw the topic, I thought it was the best one we received so far. But that's probably because it touches on governance and the kind of things which I'm more into than the others, which Professor Greg and Dr. Grima are more familiar with. But I think that it was very challenging to create arguments for the for and the against. Our students rose to the challenge with their coaches, and I'm very satisfied today with not just with my team's performance, but also I'd like to congratulate the students from University of Texas on their excellent performance. It wasn't easy. I think it's, debating against presents its own challenges. So well done for rising to the challenge. And thank you, everybody.
Thank you very much. And once again, really well done to the two teams. It hasn't been an easy topic. And if you have been following other debates of the round of 16, you might see other nuances of the technology development and the challenges it poses to law. In the opponents for the quarterfinals, for the winner of this debate, are also debating on the challenges that come with the new technologies and innovations. So you might find the next matchup strategy from there as well. And as we are passing about and talking about the challenges and rising to opportunities, I want to give you the floor if you would like to share what opportunities, initiatives, or programs are there in your university faculty that you believe have the most contributed to your growth as law students. First, perhaps to University of Texas at Austin.
Yes, I think that I can probably speak for all of us when I say that the Texas speech and Texas debate teams have been a really formative part of all of our college experiences. I would say that I've gained a lot of confidence in throughout my 4 years at this university based off of being able to attend tournaments, learn from my teammates and opponents over time. And I think that that's been very helpful, as well as it's taught me how to adapt to new topics and argumentation very quickly. And so I think that that has been a really informative program for me.
I was going to give the exact same response. LJ put that very well.
And just to add on, a special shout out to our director of the Texas debate team, Brendan Benke, for helping us create this team, organizing us. That's the opportunity. These are the types of opportunities we get from this team, and it's a really awesome opportunity to have been given.
Thank you. Thank you for sharing, and all the best also to your supporters at your home university. Now, same question for the team in Malta. What opportunity, initiative, or program you consider as the best contributor?
So from our end, I think our faculty offers a number of opportunities, which I think I'm very grateful as a student for. Firstly, I'd say how much they prioritize extracurriculars. Me as a student, I get the opportunity to travel quite a lot as well on behalf of the university, on behalf of the faculty sometimes as well. And I think that it's really pushed within our faculty as well. For example, recently, some students had the opportunity to visit the courts of justice of the EU as well. And now it's been expanded to all years of the law course as well. So I think it's something that's quite a nice opportunity for them to go up and learn about the institutions firsthand and witness it, I think, from a closer perspective. So again, once again, a huge shout out to our mentors, including the dean and the other professors as well. Thank you so much for all the contributions.
Just to add on to what Michael mentioned as well, total agreement with him, and even the fact that the faculty is very supportive also ensures that the resources that are available are exploited well by the student and that they're made known, and so we're able to really make the most out of them. And to complement that, we also, especially in the Faculty of Law, we have a very active student body in general, but we also have quite a few student organizations which are law focused that also organize many activities with which the faculty offers their support as well. And there's a lot of diversity because there are student organizations, law organizations that offer you more tips when it comes to actually entering the legal field, others which offer moot courts. So I think the support is really lovely, and it also gives different students the opportunity to invest themselves and to learn more about areas of law that they're specifically interested in as well.
Thank you. Thank you to the two teams for sharing. That's quite interesting, and perhaps there is an overlap in regards to your teams that might give you opportunity for further engagement throughout or after this competition passes as well. For the exchange, it's always interesting to have, I would say, knowledge of practitioners into other jurisdictions. And on that note, speaking of jurisdictions, what would you say are the nuances or perhaps common misconceptions about your legal system or approach to law within your countries? This time starting first with University of Malta.
What I can say is an interesting fact about our legal system is that it's a mixed legal system, which is really interesting, especially in our first year of law. We're taught about comparative legal studies as well. So, for example, our civil law is heavily influenced by, Roman law, and then the continental legal system, French, Italian, etc., by the Code Napoleon, etc. And then you have our criminal law, which is heavily influenced by Italian jurists. So we're always mentioning this famous Francesco Carrara. And so it's really interesting that even when it comes to us studying the different units that we have to study, we need to look at different sources and interpret them in different languages as well. So it's always good to have that linguistic knowledge to help you to be able to interpret the primary source. But yes, that is an interesting fact about our jurisdiction.
maybe if I could add a small point. So my point was also going to be on our hybrid legal system. Of course, it's a very uncommon to have civil and common law, so mixed and influential in your law. However, maybe if something else I could add, seeing our audience is also a non-European team, is of course being a member state of the European Union. We have a lot of decisions that are taken on a European basis where the competence belongs to the European Union. So sometimes they are directly applicable to Malta as well. In that case, the EU would take precedence, and we would have to look to EU law to interpret that first as well. However, Malta has some exclusive competences of our own as well. And apart from that, apart from other countries as well, we have our own bases that we negotiated upon our accession into the EU. We also negotiated certain terms to enter the EU. So some certain laws affect us a bit differently from other countries as well. So those would be my little things as well. Thank you.
Thank you. It's interesting news to share. Thank you. And the same question to the team of University of Texas at Austin.
I guess I can start. Something interesting, I don't know if it's a misconception, but something interesting about our legal system. I know that all 50 states have their own constitution in addition to the actual United States Constitution. But the interesting fact about that is I really only know the Texas one. I think it is about 20 times longer than the official Constitution of the United States, which I think is interesting that one state's constitution is that much larger than the country's.
I think also just to add on to that, I think the most interesting thing about our legal system that might be surprising to people in the international community is just how old our Constitution is. It was written in like the 1700s, and it's still the same governing document that we've used the entire history of our country, essentially. And, you know, there's a lot of debate about whether it should be reformed or not, but the fact is that like all law is completely based on this document written in the 1700s, and that kind of influences how we view the modern world because we're so grounded in something so old. It shapes the way that our modern government and legal system operates.
Yes, just to add on to that, I thought it was really interesting how you all highlighted the split between or the like dual system that you all have. I feel like in the United States, it's honestly a little bit more of a split between state power versus federal power, as kind of Gordy and Rita were getting at. So there are areas of the law that are explicitly regulated federally, and then all of the other issues are left up to the states. And so there's constantly disputes about which part of the government gets to regulate what. And I feel like those are at the center of a lot of American political issues.
Thank you. Thank you everyone for sharing. Quite exciting indeed. I just also want to highlight before we move on to waiting for the results and to other debates actually that are happening on the round of 16 later today, is that for University of Malta and for University of Texas at Austin, it is for your case both times that your teams are representing your institutions. First time your institutions are present in the tournament, and you have directly passed to the round of 18, so to the 8 finals. Well done. This has also marked the entrance to the World League debate for your teams. The final rankings will be completed in June, of course, after the finals. But for University of Malta, there is also direct entrance to the European zone, so specific ranking for the teams representing from the European region. And for University of Texas at Austin, it is for the North American zone of the tournament. And you are quite evenly matched because it's your first participation, first 8 finals, straightforward to it. And for both of you, you have won 3 matches so far directly. So a good start and quite exciting to see the quarterfinals. I think the judges will have quite a tough time choosing. So it's really been a pleasure. Well done. And I'm passing to Professor Lorange to wrap us up.
Yes, and I will just add indeed that the winner of your match will have a match against the winner of another round of 16 match, which will take place in 1 hour from now, the other match, between McGill University and the University of Nairobi. So you can watch it if you have a bit of time this morning in Texas, or this afternoon in Malta, to see your future opponent eventually. And we, of course, encourage you to keep contact between the two teams. So I have to say that I'm very fortunate to have visited Austin when I was 4 years old, a long time ago, because my father was working in Houston, Texas, and I've been visiting as well Malta. So I've been in your room where you have the mode court room, I think, next to the office of Professor Miss Sud, that I met in person as well several years ago. So yes, congratulations. That was a pleasure, and again, well done for this match. And we keep in touch, of course, for the rest of the competition. Thank you again, and see you soon. Bye bye.
Thank you very much. Thank you.